Hello, we are here today. I'm here with Steve Wise from Schwartz Metzen Wise, one of the premier lobbying firms in Annapolis who represents multiple health entities, and most importantly, from my perspective, MedChi, the Maryland State Medical Society. And we're going to be talking about really exciting changes to Maryland law that occurred this year with regards to non-competes. Welcome, Steve.
Thank you, Gene. Happy to be here.
All right. Well, you were the point person on this legislation, and Steve Wise, for those who don't know him, is a prominent Annapolis lawyer who's been lobbying for over 25 years, and he worked really hard on the non-compete issue in Annapolis, which was a MedChi priority. So MedChi really set policy saying that we didn't like these non-competes in the fall, and almost winter. It was November of 23, and you guys took action. So what happened once MedChi kind of set the policy? What did you do as the MedChi lobbyist?
Delegate Hill was interested in putting in this bill, and she was approached by not only us, but by the bill also applies to veterinarians. So she was approached by multiple professions about putting this bill in, and she did so along with Senator J.B. Jennings over in the Senate. His bill was rather late filed, so didn't really get committee consideration, but Delegate Hills did.
And Delegate Hills kind of did have a full hearing and everything, like you said. So why don't you just walk everybody through the process of what happened with regards to the legislation that was introduced in this year in 2024 in the General Assembly session?
Sure. So as her bill was introduced, it would have banned non-compete clauses altogether for anyone that is licensed under the health occupations article. So that's not just physicians, that's nurses, respiratory care practitioners, podiatrists, you name it. Anybody that's licensed under that section of the law, it would have been banned. And the bill went on to say that it would be retroactive, meaning it would ban any existing employment agreements that contained non-compete clauses or restrictive covenants, as they're also known. As it progressed through the House, the retroactivity clause was removed over constitutional concerns because there are clauses both in the United States and Maryland Constitution that relate to the impairment of existing contracts. And based on an attorney general's letter of advice and general knowledge of those provisions, the House decided that rather than risk the bill being challenged on those grounds, it was best to take the retroactivity clause out. As for the bill hearing itself, MedChi and other healthcare interests testified in favor of the bill. The Hospital Association, MedStar, and maybe others all opposed the bill. But it was clear from the hearing that the House committee was very much in support of the bill. And at that point is when I realized we had a chance to get this passed this year in its first year of introduction, which is very unusual in Annapolis. It normally takes 2 to 3 years to get a big bill like this one passed.
So, we go through the process. You have the Maryland Hospital Association opposing you. You have all these large, very powerful entities saying, we want to keep things the way they are. And you had really good hearings in the House. You get over to the Senate. And what ends up being what does the bill finally look at? The one you actually got passed that went to Governor Moore's desk for signature.
So those interests that you mentioned went to the Senate Finance Committee where the bill was considered and asked for a number of amendments. They wanted to kind of reduce the scope of the bill if they could, but I think they also recognized that they were not going to be able to stop it entirely. So they offered some amendments that would have continued to ban non-competes for those health occupations where the employee was making less than $300,000, and then above that salary level, it would have imposed a restrictive barrier, if you will, to non-competes by saying you can continue to have them, but they would have to be limited in time and scope. So while we would have preferred to have a complete ban, we recognize that the hospitals had gotten their arguments together on the Senate side, and we're making a little bit of headway. So we worked with that compromise that I just mentioned, but we went back and asked for some changes to it. And among those changes, we're raising the salary level up to $350,000. We did a little bit of salary research to make sure that we were encompassing as many specialties as we could at that salary level. We also push for a 10-mile limitation on the restrictive covenants. A greater number had been pushed by the hospital association. And we also, very importantly, wanted to make sure that that distance was measured from the physician's principal place of employment. Because with some employers, we had seen that if a physician worked at any of their locations, they were measuring that distance from all locations, regardless of how often the physician worked there. So that principal place of employment amendment that we asked for and got, I think, is one of the most important provisions in the bill, because that way the physician's restriction, the 10-mile radius, applies strictly from that principal place of employment and for no more than 1 year. So that's really the bulk of the contents of the bill. There's also a provision in there that if a patient is aware that a physician has left, the employer has to provide information upon request to that patient as to where they can find that healthcare provider, so that they're not left searching, which is often the case today.
And that's really important, because obviously the goal is to protect the physician-patient relationship, and that really helps do it. I also think that primary place of employment is really important, because we've seen multiple contracts, as you pointed out, where they're in different spots going forward. So we get the bill passed with the amendment. Essentially, the bottom line is, if you make less than 350, total ban. If you make more than 350, significant restrictions to non-competes. And Governor Moore signs it into law. Interestingly, a day or two after President Biden and the FTC announced that we are going to have a new FTC rule. So how does the FTC rule affect, if at all, the Maryland statute that we just passed and was signed into law by Governor Moore in May of 2024?
I think the short answer to that is initially it won't. And in the long term, how it affects the Maryland law is to be determined. And let me elaborate on that. The Maryland law, the bill actually becomes effective this October or June 1st. But it doesn't affect agreements until after July 1 of 2025. And that was, again, an amendment that we agreed to, recognizing that employers needed some time to adjust to this. So the bill becomes effective, but it's agreements after that date of July 1, 2025, where the provisions of the bill will actually start to affect these agreements. So with the governor having signed a bill, that is all going to happen. Layered on top of that is the FTC rule, which, as you mentioned, was moved toward final adoption shortly after our session ended. The key thing to know is that the Maryland legislation is more restrictive than what has been proposed at the federal level, which is important because from a preemption standpoint, states are allowed to exceed the provisions of final rules, but they can't have legislation that is weaker than a final rule at the federal level. So Our bill is more restrictive in the sense that we have applied it to nonprofit entities, um, and not just for-profit entities. That issue is going to be one of many that is likely to be litigated at the federal level over whether nonprofit entities are truly covered by the federal rule or not. And the FTC talks at length about that in the final rule. And I think we can all anticipate that that will be one of the points that's litigated as that federal rule makes its way through the process. It doesn't become effective until September of this year, but lawsuits are already in the works to challenge that. We also have a federal election coming up, so lots of things can happen with the federal rule, but the Maryland law is on pace to take effect regardless of all that.
Right, and the law's been signed into effect, and I think most of the lawyers I speak to, and you and I are both lawyers, obviously, and we believe that we're not preempted, so I don't think that's going to be an issue. So, if you're in Maryland, probably focusing on the Maryland statute makes a little more sense, and you can keep your corner on your eye on what's going on with the FTC and what's going on with the litigation that was filed within the week of the action by the administration. So,
That's right.
really an exciting victory for physicians getting this legislation passed. MedChi had a great session, and we've worked with your lobbying firm now for how many years, Steve?
I came here in 2002, and I think that the firm had already represented MedChi for 8 or 9 years prior to that. So
Yeah.
we're in the 30-year range at this point.
Yeah, so it's I know that I know it's been a long time. I've been with the Medical Society 27 years, and every year I've been here, you guys have been here. It's been an incredible partnership, and results like this one show why. You guys do a great job for us, and we appreciate you. If anyone has any other questions about this, or any other healthcare related legislative item, the MedChi website has a really good summary of all the work that Schwartz Metz& Wise did for us this session. And we are also going to be doing videos on some of the other big issues we passed this year. So stay tuned for those as well, including the prior auth legislation and some other stuff we worked on. Thank you so much, Steve, for being with us today.
I would just add one thing, Gene, before we go. Thank you for your compliments of our work, but it's also the product of our physicians being engaged in the legislative process. And this bill's a good example of that, where we had a physician come down and testify and others write letters who had been affected adversely by these non-compete clauses. And it's a combination of our efforts of being down here and knowing legislators, but also our physicians being actively engaged in the process that gets us to these kind of results.
And I think that's a great point. I'm glad you brought it up so we wouldn't forget it. MedChi runs the first aid room. We have doctors who do that. We do various days where we come down and meet with our legislators. But on this issue particularly, there was a lot of activity. The grassroots activity, the value of that cannot be understated. You can be really smart and know the rules and know the process, but if you don't have the people behind you, it's really hard to get anything done in Annapolis.
100%.
Great point. Thank you so much, Steve.
All right, Gene, thank you.